All right, good afternoon, everyone, and welcome to another edition of Fire Law Roundup for June 6th. June
Yes.
6th, and I got to deal with a technology issue here. And all right, good afternoon, everyone, and welcome. There we go. All right, and I've got to welcome my good friend Paul Doughty to the program. Paul, welcome first of all.
Thank you. Pleasure to be here, Chief.
Well, I'm really happy to have you, and I wish we could have gotten you on sooner. But Brad has got a trial. Billy Macarone's in the firehouse, and you answered the phone, and I really appreciate you stepping forward. And for those of you who aren't familiar with Paul, Paul's been in the fire service now almost as long as I have. You got to be in the 40 total years, right?
I started when I was young.
Yeah, me too.
I'm only 40.
There you go. And but Paul is an attorney. He was the president of Local 799 for how many years were you president there?
14 years.
14 years. And that's I always say the most hated person in any fire department is the fire chief. Okay. The next most hated person is the union president.
True.
Okay.
Very true.
And there's people constantly sharpening their knives for you. And I know that you've got a wealth of experience. I know you do a lot of teaching with us as well. So, but let's kind of jump into it here. And the first case, we're going to do it a little differently. We'll have the cases up here on the screen. But the first case we covered was a lawsuit out of Illinois. Paul, I don't know, did you have a chance to look it over? Do you want to kind of?
Yeah, briefly. So this is a case out of Illinois. So work-related gender-based discrimination. The firefighter in this case committed suicide, and there's allegations that the fire department created a discriminatory work environment along the lines of a hostile work environment. The firefighter in question had really a stellar career prior to that. Nicole Hadlick, I believe I'm pronouncing that right, had wanted to be a firefighter for a long time, and she had exceeded and really excelled in a number of previous assignments with some other training academies, and then moved on to Hinsdale. And she had worked, according to the complaint, she had worked well with the previous officer who was supervising her, and then switched shifts. And then, again, according to the complaint, that's where the issues began. It really described as a systematic pattern of conduct to break and force her to quit. And some of that was driven by training evolutions that were different than other firefighters were subjected to, which I want to talk about a little bit more. And her husband is also a firefighter there, as I understand it. And also allegations of intentional infliction of emotional distress. So it's a complex issue, tragic consequences, and at least the allegations are beyond concerning. I want to point out before we start that this was the context of the case. One of the first things we look at is what is the posture of the case? Where are we along sort of the litigation path? This is a really early stage. It's a motion to dismiss. And survive the motion to dismiss, and that's the lowest bar. So this is just the start of this case, and they did get over that first bar.
Yeah, and couple of things when I read a case like this, and I've seen cases where we have a problem employee, and they're looking for an excuse. They have some competency issues, they have some attitude issues. You have officers that are trying to do the right thing and get that person to the point where they can become competent and get along and work well with others. And they perceive that as harassment. So we'll call that sort of condition A. We have that as one case. We also see situations where an employee is a good employee. And we have some maybe problem officers that are subjecting that person to really unnecessary scrutiny, inappropriate scrutiny. And particularly when the person is in a protected class, it just it sort of gives them sort of an extra card in the deck in terms of dealing with that. And, which of those two is going on here, we can't say. It's really hard. I've seen both of them in play. Paul, your career, like mine, it spans several departments, and plus our counseling of other departments exposes us to a lot. We've seen both of those, and what's going on here is anyone's guess. All we do know is that it unfortunately resulted in a suicide, and this is not the first suicide that we've seen with similar types of fact pattern, with a similar type of fact pattern. So certainly it's something that we've got to pay attention to.
I want to talk about a couple of things. First, the plaintiff was the only current female firefighter in the department, and I don't have a sense of how big they are, but nevertheless,
I think it's 2 stations. I believe it's 2 stations, so not all that.
So on the order of probably 20 folks or so, or in the teens. First firefighter, the only currently employed female firefighter. During their 100-year history, they had 2 previous female firefighters. So I think there's oftentimes a lot of tension from the firefighters that are there beforehand, before they have to work with a firefighter. I think often there's comparing between, well, if women can do my work, then it doesn't put me in a special category as a firefighter. And throughout the country, we can see that that's not the case, that there's an equal footing in almost all cases, and certainly when we're speaking generally. And I think at times fire officers, and I've seen this not only with minority firefighters, but just junior firefighters in general, that there's this heightened requirement for them. And sometimes it's under the context of competency, but sometimes it's under, I'm going to use my authority as a company officer to really show you that you don't know what you think you do, that I know more than you do. And it's a way both can be used to teach. It creates peer pressure. And in some cases, it can be abused under the context of training. So it really, if there's not good supervision, and as we say, it all comes back to leadership, these kind of tactics that may have some basis, some need in the fire department, can be weaponized. And as you said, we really don't know what the tone or the tenor that this extra training, my words, was implemented. But it certainly raises some questions when works comfortably and admirably and reportedly met all competencies with one officer and then switches to another group or shift, and then the problems in this case, as they're alleged, begin.
Yeah, that is exactly the concern I have. And I think back, I like to use the metaphor of the drill sergeant, the prototypical drill sergeant, like a Sergeant Hartman from Full Metal Jacket. And, there's a certain mindset that officer, that Sergeant Hartman, in his mind, in his heart, he is doing the right thing. He is trying to get people to conform to what the organization needs, or his vision of what the organization needs. And we do have officers out there that sort of model that Sergeant Hartman behavior. And again, I'm not saying that's what's in play here. We don't know, but I've seen it. I've seen it. The state fire academies a couple of miles away from me, and I go down there and teach and do different things. And I see officers or well-intentioned instructors sort of modeling that Sergeant Hartman behavior. And when you start throwing in a protected class, and certainly
inconsistent application.
Yeah, no, absolutely. And again, you look at some of these other cases. There was one from San Francisco we covered a couple of years ago where there was a Muslim candidate, a recruit, and apparently one of the drill sergeants, the firefighter was, they were doing a ground ladder carry, and the firefighter, how you go down for the ladder, you turn, and the firefighter was facing the wrong way. When he stood up with the ground ladder, he was facing the wrong way. And the drill instructor said, "What the F? Are you facing Mecca? What are you doing?"
Classic.
And I think that we've got to recognize that maybe what works in the military, what worked for Sergeant Hartman back in the Vietnam era, it doesn't work in the military so much anymore either, but it certainly is not going to work in civilian life. So difficult case.
Yeah, and I think there's sort of, from a practical point of view, the difference between nickel and diming a trainee or a new firefighter and really trying to instill some muscle memory or some emergency actions. And I can see sort of a spectrum of how hard or how harsh we may reprimand a firefighter based on sort of the skill that we're trying to share with them.
That's good point. All right, the next case is one that also is very concerning in so far as it's like the third one in the last year or so that we've covered here on not just the firefighter using drugs or selling drugs, but what we're talking about is multiple firefighters being involved in some sort of criminal conduct related to drugs. The concern I have is that it's almost like a very casual approach to this. I know in my career, if someone was dealing drugs, I mean, we always had suspicions about who's on something, but it was always kept very secretive. It wasn't, you wouldn't hear firefighters openly talking about dealing or using, or at least the firefighters you and I hung around with anyway. But there was always people. My point being, drugs in the workplace is not, it's not a new phenomenon by any stretch. What we're talking about here is multiple firefighters texting. I'm assuming if they're texting, they're probably talking about it. Very casual approach. And this one is in Mass. I don't know, Paul, I don't know if you've had any connection with Malden Fire.
I may have done some training there
a
couple decades ago, but squared away place.
Yeah.
From all reports.
Yeah, and but they had a firefighter. Unfortunately, this one, unlike the other two that we had covered previously, the other two being New Britain, Connecticut, and North Las Vegas, Nevada, both of those involve multiple firefighters, drugs in the workplace or drugs transactions and different things happening, and a fatality associated with it. Fortunately, here in Malden, it did not get to that point, but we've got a firefighter who's accused of selling drugs to colleagues. The drugs included oxycodone, Suboxone, Klonopin, and Adderall. It's concerning to me. Paul, I don't know if you have anything you want to add here.
I think a couple levels. One, sort of the fire department is a reflection of society, and drug use, at least in my corners of the world, seems much more prevalent at that casual level. So I think you're seeing it not completely widespread across all classes and groups of individuals, but it seems once it gets a hold, given its addictive nature, it becomes more widespread, even amongst smaller groups in fire departments. And with the potency of it, it becomes much more dangerous than the drugs of before. And I think, it kind of sound like the old guy now, but it seems that any drug use, at least that I had seen, was more of a one-off, and it wasn't widespread amongst firefighters. There were times where I certainly had suspicions, but it was one firefighter, not groups of them, and not dealing amongst themselves. And I don't know all the facts of this case. I do know it was a federal case, so it had some attention of some important people rather than just a state case. So my guess is there was some dealing that went on outside of the fire department, but sort of the things that we're facing and seeing and responding to in the community are also in our workplace. And it comes back to leadership. I think it's the expectations we set on the company officers. There's a pivotal person in terms of the department to really ask the question, hey, what's going on here? And then what do I do with it? So is there a sort of a both a EAP type of setup that do I have a place that I could put these firefighters? Do I have the support of the leadership above me and below me, or my subordinates below me, to actually ask the question? And without those components in place, a company officer's kind of out on his own. And my guess is in most places where this is occurring, it's not just the people that are in the conspiracy or involved in the use of trafficking. It's beyond that. It's something that's hard to hide from people that you live with 24 hours a day. So that would be kind of my thoughts on looking at this.
Yeah, I had a conversation with a family member who's in law enforcement about it, and he was talking about he didn't use these terms, but I think most of the folks who are listening here will get it. It's the normalization of deviance, but that pop culture today, whether it's music videos, movies, has sort of normalized drug transactions and drugs in general. To a degree that certainly wasn't the case when you and I were kids. And the impact that may be having on sort of normalizing this, making it sort of acceptable part. And almost like, when he said that, it made me also think about violence and guns. And I know you and I are both Second Amendment advocates, but you got to wonder about the role. It makes me wonder anyway about the role that pop culture and again, music videos and movies and TV shows and video games and things like that are playing, which just wasn't happening when we were kids. I mean, when I was a kid, we were watching John Wayne movies it wasn't the level of violence, and certainly drugs and different things just weren't what it is today. So.
And I don't think the drug use was as widespread, even in some of the neighborhoods that we worked in. I mean, there was a significant presence of heroin, but it's much different to me in terms of how many households are affected, how many responses have some factor related to substance abuse. Mm-hmm. And I do think there's some normalization, and Narcan, I think, has played a role in it. Unfortunately, that it's undoable now. We can make a mistake and come back from it, which is a positive thing, but it just lends to, I think, more casual use.
Yeah. Next case is back to California here, and really kind of I've been following this particular firefighter for a while now. He's got four lawsuits against the department, the Montebello Fire Department, alleging race discrimination. All four of them allege various forms of race discrimination, but he prevailed in the first one. He filed in 2013, 2017, 2020, and now he's filed the fourth one here in 2022. He prevailed in the first one and was awarded $935,000. So pretty substantial jury verdict. First three were in state court. This one now is in federal court, and it alleges essentially retaliation for his prior complaints, and that I believe he said he was passed over for promotion, and so you can sort of read the details. I don't know, Paul. What are your thoughts on this case?
These cases, to me, kind of fall into two ends of the spectrum, and often it's a protected class, or it absolutely is a protected class. But sometimes there's some toxicity that's involved with that as an employee, or challenges with the organization and that firefighter fitting in. And then other times, I think that the administration is just flatly, we're not changing, and no one can make us. And when you're playing with other people's money, sometimes it's easier. Also, I've seen cases where they, once a case is filed or the allegations are made, the complaints brought forward, it kind of freezes, in some cases, the fire department from their ability to make any changes, because those changes may look like, see, that was my point. You had to change this policy because I raised the issue. So it puts everybody, I think, on eggshells in the administration on what they can and cannot do. But certainly this could be at least a short novel with four allegations, and one successful one, a significant one. So it raises the question, where's the issue lie? Is it with the plaintiff, because it was not in at least the case where he prevailed, or is it with the administration, or less likely is it some mix in between? But again, it comes back to leadership. How are we going to treat this, especially after it's been raised? Once a settlement was made, it's a chance and an opportunity for the fire department administration to reset. The last thing that I'll add is sometimes the fire chief's dealing with the day-to-day situation and the initial circumstances, but they almost never are the person that decides the settlement. And I have some cases I've been involved in where the department simply settled because it was the easier path rather than expose itself to long-term litigation. And those decisions are taken out of the chief's hand is the point. I'm not saying which side was right or which is the best practice. There's a lot of variables and ways to look at it, but the fire chief's not involved, at least in the cases I'm familiar with any of those decisions. So front side, yes, back side, almost none.
Yeah. And then you could almost see where if a non-meritorious case is settled, then somebody could come back
exactly
a second time or a third time saying, you settled once and there was no corrective action taken. It was just the settlement. So, and we're not saying that's what's going on here. Again, this one's 3,000 miles away. We have no idea what's going on in this case, but it just, I noticed when I passed the bar in 1985, and almost immediately, I started meeting people who wanted me to file suits for them. Many of them were firefighters. And I also happened to notice that they seemed to enjoy going to court more than I did. And I'm doing everything I can to try to settle these cases and try to get them the result that I think that they wanted. And they're like, no, we want to go to court. I want to go to court and I want to prove to them that I'm right and they're wrong. And so there is a group out there that is inclined to weaponize the legal process to try to prove themselves to be right. And again, I don't know. That's one of the questions that comes up in a case like this. Is this that type of person? On the other hand, there are departments out there that just they have not gotten the memo. They just
at all.
And so you have a heroic figure that just is willing to stand up to it and say, we've got to fix this. And I'll be the one to carry the load. I'll pull the horse. I'm the horse that'll pull the wagon to get this fixed. So who knows? Who knows what's going on? But I agree with you. It's probably not in the middle on this one.
No.
So, all right. Next case, okay, is a really good one. I don't know, are you up on this one? Do you want to kind of introduce it for us?
Yeah, I'll do an overview and then kind of back into some more specific issues or items in this. But so this is a fire department in Virginia, and they have an internship program for paramedics. So let me see what his name is.
Yeah,
Lyons.
Right.
Firefighter at Lyons, I'm assuming that's his rank, was trying to avail himself to the paramedic internship and had taken the paramedic class. And it's with any of the EMT classes, very difficult. So he had several times that he had to take this. I think it may have been up to 6 times that he took it.
Yeah, I think he passed the final exam on his sixth
try. So It goes to show how difficult it is, and also how much perseverance he had to be able to pass that and continue doing it. In any event, he passes it, and now we start to look at the intricacies of the fire department and how assignments are given out, when they're given out, to whom they're given out. This firefighter, I believe, was a member of a protected class. And his allegations were that I was passed over for placement in my internship. So traditionally and very superficially, the fire department would kind of do it on a first come, first served basis, with one caveat. They would try to keep it on the same shift. So it wasn't a flat first come, first serve. It was within the shift. So this firefighter put in for his internship after he was successful, wanted to get assigned to an EMS unit or to that paramedic position. and did not get the first one available, made the allegation that he was passed over because of his race and his protected class. And it went to, I believe it's a summary judgment. So again, we looked at the posture of the case and to see where we are. So it's not a verdict, it's just saying a summary judgment. If we take a look at all facts in the other party's favor, would we be able to move forward?
Yeah,
in this case,
yeah, the trial
go
court
ahead,
said
Jim.
no. The trial court said no. The trial court said, look, you have created a prima facie case of discrimination, but the city has offered an alternative explanation for a non-discriminatory reason. In other words, that you didn't get assigned, and as I understand it, it sounds like when you pass paramedic, you've got to be assigned to the equivalent, the police equivalent of a field training officer.
Right.
But
On your shift.
But it's going to be on your shift, right?
As they described the practice.
Yeah, so that they don't want to have one field training officer supervising too many paramedics. So it's supposed to be, I guess, 1-to-1. And so if you're going to get this internship, there has to be an opening, and but we do it on shift. And there was also, if you read the folks who want to get into the nuances here, there was also a shift change that this firefighter had voluntarily transferred shifts, which sort of changed, it sort of reshuffled where he was in terms of getting those assignments. But at the end of the day, the court said that, the fact that you are, I believe he's African-American, the fact that you're African-American and you put in for something and you didn't get it creates a prima facie case of discrimination. However, that's all it does. It creates a prima facie case. Then it's up to the department now to respond.
The burden shifts, and the employee in this case has to say, a member of a protected class, some action was taken.
Right.
That's the prima facie case. Then the burden shifts to the employer to kind of explain why this is non-discriminatory.
Right. And then
they met that burden.
Yeah. And as long as the department has a non-discriminatory reason, then now the burden is going to shift back to the employee to show that that was really just a pretext for discrimination. The most likely or the easiest way to show that it was pretextual is to show that they have not followed a consistent procedure. They haven't done it that way. And that here's several examples where they didn't do it that way. And he was not able to do that. He was not able to respond on that, I guess, the third burden shift, right? Starts with the plaintiff, goes to the fire department, then goes back to the plaintiff again. He was not able to show that this was pretextual, that the department had consistently handled the assignment to this internship on a per shift basis, and therefore the case was dismissed.
And so just a couple seconds on the pretextual part. So the pretextual, as a fire chief or fire administrator, is where you kind of take the rule and you say, well, but it also meets this one, and this one. So you've made the decision, and then you kind of back into what the support is. I think the facts as we read them here in this case are much, much different. They had a policy. Now, it doesn't mean it has to be applied evenly 100% of the times, but it has to be consistent. And they pressed the chief on it, and it was within your shift. And there's a good reason for that, because if you had just by chance, say 5 firefighters on A shift and none on B and none on C, you can't have all 5 necessarily go to the field training officers, because maybe there's 1 or 2. And so it's by shift. And in this case, the firefighter had moved shifts, so it changed him again from one shift to another. But I think the explanation that was provided by the fire department in this case makes a lot of sense. First come, first serve within your shift. It lets us presumably keep even time, overtime more even, and we don't have to bear that burden. And when your time comes up, it comes up.
Yeah. And so I think there's an important lesson here for fire departments, and it's the importance of following a consistent practice. If the department did not have a consistent practice, this case would not have come out the way it did. They would have lost on that third avenue there, that third burden shift. But as it was, they followed it consistently. And my dad always taught me, he said, hard cases make bad law.
Yeah, absolutely.
When some big corporation wants to evict a little old lady on Christmas Eve out of her apartment that she's lived in for 40 years, the court is going to kind of find an excuse not to do that. And that in turn sets a precedent for the next case when it's not Christmas Eve and it's not a little old lady and so on. So fortunately, in this case, the department stayed consistent. They didn't allow some of those day-to-day types of reasons that can cause us to deviate from a practice to sort of muddle this issue. But you can see in many departments sometimes where we don't follow a consistent practice. That's where you can find yourself sort of in the jackpot.
And the last thing I'll add is not only is that consistency an issue, but I think it's a solvable issue for fire department leaders. I think the bigger challenge maybe is when you're just beginning a practice. So you kind of need to lay it out and think of as many eventualities as you can, because when you're just beginning a new policy is when this case may have turned on a different point. If this policy had been only a couple months old, but from the facts of the case, it seems like it had been a fairly long-standing practice.
Paul, that's something just as you were just talking, something dawned on me that I've seen you do as a union president. But when you have a department that handles something in a certain way, and there's going to be a need for us there's something unusual about a situation, you add something into the agreement that says that this deviation is not going to set precedent.
A couple of ways. So we deal with past practices. So if a contract, this is Rhode Island law, but if a contract was ambiguous or did not speak about a practice, either party could file a letter to the other side saying we're going to end this past practice, whatever it may have been, and we're going to move forward with what we think. Usually it's the administration. We're going to move forward with what we think that the practice should be because the contract is either silent or doesn't speak enough. The other thing to remember for CBA states or states with collective bargaining is that if it's a change in working conditions, as I discussed that new practice, you can file a request to bargain over that. So if it's something that's not in there, as a union, you didn't know it was going to be in there, and then say you're going to add EMS, or this whole program was started at some point, that would be something that I might say I file a request to bargain over. And I get the tension sometimes between the chief and the union who's running the fire department. But in the best case scenario, we just work out how is this going to be applied, and often two heads are much better than one on thinking about how do we want to do this, how do we want to make it fair, and how does it work as we move further down both the path and the application of it.
Mm-hmm. But I know that you have, and I've seen some of your agreements to settle grievances include a provision in it that says that this does not set precedent, that this is, we're agreeing to settle this particular grievance this particular way, but it's not intended to set precedents. And I guess my question is, I wonder if the department had deviated sometime in the past on the way that they were going to handle this. What would the impact? And again, Virginia, at least at the time, Virginia recently became a collective bargaining state, by the way, just recently. But assuming that they were a collective bargaining state, I wonder what the impact of that kind of a statement in the settlement. Like, let's say for 10 years, they've done it in a certain way, but then once they deviated, but it was with the union's consent and they agreed that it would not have precedential value. I wonder if that would have given this firefighter the chance to say, aha, you didn't do it consistently.
Perhaps that's often when I handled grievances, that was something we had to consider, just taking the grievance. And it's one of the reasons that individuals can't file grievances, because you could set precedent that maybe ran directly in opposition to what the union's thoughts or desires or practices were. So I could see that it's a potential pitfall for both sides to not address that. And sort of the cleanest way to do it is to say this does not set practice or precedent, particularly in settlements. In most of the bigger cases, terminations or last chance agreements, that was absolutely a provision in there.
Yeah. All right. Well, I think we had a couple more articles. I don't think all that much. We did. Bill Macarone and I did do a vlog last week just on some proposed changes to the Department of Labor's rules on overtime, and in particular, the possibility that the Department of Labor is going to increase the salary requirement for exempt executives probably isn't going to affect career departments, certainly on the West Coast, because their salaries are so much higher than the rest of the country. But there is a possibility that it could have an impact on some fire departments, particularly down south, and in particular, departments that don't have a full-time chief, maybe a part-time chief, but that chief is paid a salary. Currently, the minimum salary to qualify as an exempt executive is $684 a week. So if you have a part-time chief that's getting more than $684, they can qualify as exempt. But if not, even though they otherwise qualify, and I say I have a number of clients that are sort of in this position right now. They are a full-time firefighter in one fire department. They're serving as the chief in a smaller department, so they're part-time. Right now, they've got to get at least $684 to qualify as exempt executives. If they don't, they've got to be paid by the hour. And so that can be a little bit of a problem. The Department of Labor is looking at taking that up. Bill thinks it's probably going to end up somewhere between $900 and $1,000 a week. So that's going to certainly have an impact on those departments. But we've got that vlog, about a 15-minute vlog on that. And then this is I took a look at one of the most asked about questions I get asked all the time about, can a fire department be held liable if it doesn't comply with an NFPA standard? So we won't belabor the point beyond saying there's really two issues when you say, can the fire department be held liable? What exactly are we talking about? One is negligence. Okay, can you be held liable for negligence? Well, NFPA standards are evidence of what the reasonably prudent fire department would do, but it's not absolute minimum standard by any stretch. So that's one factor. And then the other is the possibility of being cited by your state OSHA for a general duty violation. So those are really the two legal concerns that you have when you don't comply with an NFPA standard. Okay, Paul, anything you want to add to wrap up this week in fire law?
No, excited to be here. Appreciate the invitation and look forward to another opportunity.
Yeah, Paul, thank you. It's been great. It's been great to see you again. I know, Paul, for those of you not aware, Paul's up in Maine now, which
undisclosed location.
Yeah, undisclosed location with a lot of hammering going on. Yes. Is that your wife? Is that your wife hammering?
The kids and the wife, they're building a house.
There you go. And so that's great. And we wish you all the luck. And that's going to do it for another edition of Fire Law Roundup.